Thank you, and good morning, and aloha, everyone. And let me just say, for those of you who were at the reception last night, those medics, the medic with the Marshal Service is a really big help. So anyway, for those of you who saw me last night, I'm fine, thank you so much. So I'm really honored to be able to moderate this panel. In recent years, local and state governments have filed lawsuits in areas such as tobacco, pharmaceuticals, firearms, and more recently, climate change. The topic of our panel is locality litigation and public entity incentives to file lawsuits. Public interest, politics, public finance, or financial gain. We have three impressive panelists here today. The program says four. Unfortunately, Professor Baker is unable to join us today, but we do have three impressive panelists. I'm not going to go over their entire bios. You can read them. I'm going to briefly introduce them and explain what they're going to be talking about. First, Professor Paul Nolette is chair of the Department of Political Science of Marquette University's Klingler College of Arts and Sciences. Professor Nolette receives his BA from St. Anselm College, his JD from Georgetown, and a PhD in political science from Boston College. And he will focus on the politics piece of our topic. He's going to set the stage for our topic by highlighting what is not new about public entity litigation and what is new, especially in the last few years. He's going to discuss political reasons why public entity litigation has expanded over time, and which he opines has to do in part with the structure of American politics itself. So we really look forward to hearing from him. Next, we have Professor Julia Mahoney. She is the John S. Battle Professor of Law from the University of Virginia School of Law. She received her BA from Barnard and her JD from Yale, and she is going to focus on localities' involvement, and she's going to be focusing on the public finance or financial gain part of our topic, discussing localities' involvement in these more innovative lawsuits in the broader context of recent developments in government finance. I never really thought of it this way. She'll discuss how in recent years we've seen departures from the standard model of government financing, which is basically taxes and fees. And she's going to address constitutional issues that arise out of state and local government financing through litigation. And then finally, our third panelist is Professor Brian Fitzpatrick, the Milton R. Underwood Chair in Free Enterprise and Professor of Law of Vanderbilt Law School, right across the street. Beautiful campus. I hope you guys took a look. He received his BS from Notre Dame and his JD from Harvard, and he's going to focus on the public interest aspect of our title. More specifically, whether we really need government entities to pursue these lawsuits or whether it should be the private bar doing it. He posits that if the government seeks to remedy harm to itself, that might be in the public interest, but he questions whether when the government is suing on behalf of its citizens, whether the public interest is best served through the government or through private lawsuits. So we have some interesting topics and interesting speakers, and after we hear from them, I'll again ask them to comment on each other's presentations. We will also be open through Slido to questions, so please submit your questions so that I can direct them to the panelists. Thank you, and Professor Nolette, please proceed.
Great. Well, good morning, everyone. I'm very happy to be here. So as the political scientist on the panel, my job is to talk a little bit about the politics of this locality litigation public entity suits. And I decided to go kind of a general route to give sort of a big picture and put this in the broader perspective of American politics as well. And certainly happy to have a discussion and get your questions at the end. But I thought that I'd set things up a little bit by saying a little bit about what's not new about public entity litigation and what is new. So I think it is important from the outset to realize that public entities using the legal system explicitly for political and regulatory reasons is nothing new. This stretches back many decades, well into the 19th century. State attorneys general, for instance, even in the 19th century, were using creative litigation strategies as a regulatory device. So for example, there were a number of 19th century AGs that were bringing public nuisance litigation as really a sort of proto-environmental regulatory device, well before agencies were devoted to that purpose. And they also brushed off other common law theories like quo warranto to threaten early trusts and railroad companies with dissolution of their corporate charters if corporate behaviors did not change. And it is important that I think the AGs and public entities that were bringing these lawsuits saw this in the bigger scope of what was going on in American society and industrialization in the 19th century. And so, I look back a lot of the legal history in the post-Civil War era, and there were a number of really, really interesting cases. There was one from my home state of Wisconsin, which I'll bring up, where the Attorney General brought a number of claims against the railroads, and a lot of this had to do with pricing, some of the equitable pricing and versus freight and passenger and all of that, and was bringing lawsuits against the railroads, and the question was whether the AG even had the power to do so. And there was a really interesting decision by Justice Edward Ryan on the Wisconsin Supreme Court in which he said, yes, the AG should have the power to bring these lawsuits, much of which was based upon common law, and adopted the AG's arguments that really when any corporation, and this was a quote from Judge Ryan, that when any corporation is doing acts detrimental to the public welfare or hostile to public policy, the AG should have the power to confront that. And important to the reasoning there, both from the AG's perspective and the judge, was that there was now, and this was in the context of the 1870s, 1874 decision, that there was a new power unknown to its founders, practically too strong for ordinary private remedies. And this new power was the emergence of these great corporations, those aggregations of capital and power, as Judge Ryan put it, with influence so large that few private persons could litigate with them. And so really, this pops up in a few other contexts too, in other states, particularly the Midwest when it came to the railroads. But clearly, that is an explicitly political reason to say, things have gotten out of whack, even thinking back to the framing of the Constitution a few decades prior to this decision. And because you have this new power in society, something needs to balance that out. And for a number of the public entities, including AGs and some of the sympathetic judges at the time, the common law could be that mechanism for getting some political evening between these great new powers, corporate powers, and the public interest. And so all that's to say that this sort of self-consciously political use of the legal system isn't anything new, but of course there is a lot new in recent years. And most recently, of course, we've seen federal, state, local entities, public entities seek to use creative litigation to regulate everything from lead paint to guns to labor practices, large-scale public health issues like tobacco use and opioids, which I know a number of you are working on out there. And so it's really kind of like picking up the earlier litigation and cranking it to 11, to use the Spinal Tap reference. And behind this are really a greater range, number one, of legal theories overall. So especially since the 1960s and 1970s, when you had an explosion of statutory law at the federal and state level, a lot more of the common law has been codified over time and supplemented in federal and state statutes enforceable by public entities like AGs that tend to be, as a number of the panelists in the last panel mentioned, tend to be very broad. The UDAP statutes, the other consumer protection statutes that are very broad and open-ended and allow for a lot of experimentation on the part of public entities. On top of that, the growth of government programs over time, like Medicaid, for instance, involving significant state and local outlays, have given public entities more arguments to claim direct harms. So they don't need to necessarily claim parens patriae standing to get into court. So much of this litigation, for instance, against pharmaceutical companies, again, which many of you are familiar with, that has tried to reshape industry pricing and advertising practices has been linked to Medicaid expenditures, for example. So all of that sort of in the background, beginning in the 1960s and 70s, has really supplemented this long-standing push to use the legal system as a political tool. And of course, there's a lot more actors involved in all of this as well. Multi-state litigation, so thinking about the state AGs, really started taking off in the 1970s, and after tobacco in the 1990s. Localities have gotten into the act with city attorneys, DAs, et cetera, going after a number of different corporations, and private actors as well, private class actions that also bring parallel, some might say redundant lawsuits in many of these areas. So one thing that I just kind of closed in the last couple minutes here that I wanted to emphasize is that, whether you think that this is a feature or a bug, using the legal system kind of explicitly in political and regulatory ways like this, I don't think that the place of politics in litigation should be any sort of surprise. First, we're talking largely about either elected officials or officials that are, close to the, kind of have their ear to the public, what's going on with the public, and the public expects action. Even back in the 19th century, a lot of the AGs that didn't use creative common law strategies against the railroads were getting criticized constantly. They were getting bombarded. Why are you not acting? Do something. And I think that pressure to do something is even stronger in the 20th and 21st centuries from all executives, from the President of the United States on down. Certainly gone are the days where the president's job was mostly to fill federal offices, and you might have some like President Coolidge who's like, I don't really have an agenda. No, presidents need to have a strong agenda. They need to do stuff. They are expected to act, and that also applies to a lot of the leaders of these public entities like attorneys general as well. And I think also, and I'll close with this point, that I think it's important, even when we get into the nitty-gritty of all the public nuisance and common law and legal strategies here, to put all of this in the broader context of American politics. So something that's quite distinctive about American politics is the fact that it's so fragmented that it creates numerous veto points throughout the system where different entities can block action. Whether that's a literal veto of an executive or the filibuster or litigation itself, there are all these veto points, but the fragmentation also creates a lot of opportunity points for entities to get involved politically as well. And these two things interact. So, ultimately, I'd certainly make the argument that when it comes to a lot of the large-scale policy questions, it should be Congress dealing with this in comprehensive legislation, certainly climate change and maybe even the opioid crisis and these other large-scale issues, as opposed to trying to deal with everything through the legal system and public entity litigation. But if Congress is so beset with all of these veto points that it can't come up with comprehensive solutions, then things get kicked to another part of the American political system. Maybe that's federal agencies who are now using creative administrative strategies to deal with this. But then there are veto points that block those. Maybe it's litigation pushing back using the Administrative Procedure Act, for instance. So if these veto points are preventing actions in these other venues, then public entities, I think, are going to take the opportunity to respond to public pressure and in ways that make political sense for them. So you can use your preferred analogy here, whether American politics is kind of like a game of whack-a-mole, where you're trying to address one thing over here and you say, okay, well, we're cutting off this really bad way of using public policy. Well, something else is going to pop up in some other venue. That's the nature of the fragmented American system. Or you can think about it as a system of hydraulic pressure where, hey, this is good, you got public pressure, even if there's one part of the government that's captured or not acting for whatever reason, then you have other entities that can kind of fill that gap and address that pressure. So the very last thing that I'll mention before handing it over is just to say that I think that there is a lot of criticism of using the legal system to address regulatory and political problems, especially these large-scale problems, but I'm not so sure that it's anti-democratic. We've seen this in many ways, the legal system being used in this way, not just for, trying to address direct harm of private or public entities, but also as a self-conscious way to address larger-scale political and regulatory problems. So with that, I think I'll turn it over.
Thank you, and thank you very much, Justice McKenna, for that kind introduction. Thank you to the Law and Economics Center for organizing this great symposium on novel liability theories. My focus is going to be on the public finance aspects, in particular, issues relating to novel liability theories. Let me start, though, by placing some of the current debates over novel liability theories in the larger context of what's going on in public finance right now. This broader context consists of what I would call a lot of activity in non-standard government practices in terms of collecting and dispersing funds. Now, as Professor Nolette points out, a lot of what I'm discussing is not new. There are a lot of things, or certainly we can see a lot of ancestors of a lot of the practices. But in terms of magnitude, and often in terms of quality, what we've been seeing in recent decades is new. Because in recent years, at all levels of government in the United States, federal, state, and local, we have seen a number of important, but not to date well-documented, deviations from what I call the standard model, the one that you're used to from Sesame Street and probably your 8th grade civics class and so on, and even in the words of a number of leading court decisions, including some from the United States Supreme Court and so forth, under which government collects money through well-established and transparent methods by imposing taxes, in the case of state and local governments, income taxes and property taxes loom largest, and also by collecting fees. The fees in this standard model are generally proportionate, or roughly so, to the services that government is providing or to the harm that government has suffered. The standard model is a long way from the policing for profit activity, for example, that we've been seeing in recent years, which I will be saying more about in just a few moments. And in the case of state and local governments, so we of course see that they also collect money by getting a lot of money from the federal government. Now, how have things differed? Well, and then the money that is collected is dispersed with resource allocation being largely entrusted to the political branches, with the legislature taking the lead, and with there being at all stages of the process ways for the electorate, which is familiar with these processes, ways for the electorate to monitor, to keep track of what the political branches are doing. As the Supreme Court put it in a very famous case, the Standard Oil case decided in 1947, this is a proper subject for congressional action, not for any creative power of ours. Congress, not this court, is the custodian of the national purse, and the executive the arbiter of federal fiscal affairs. And these comprehend, as we have said, securing the Treasury or the government against financial losses, however inflicted. So in other words, we have a system, we have a process, and in theory, this system works well, and this system is transparent, and this system is well understood. Now, of course, that was always an oversimplified description of how money flowed when it came to government, no question about that. But what's changed? I'd say a lot. At the federal level, we see that the standard practice that the power of the purse belongs to Congress is, as Michael Grieva and Krista Muth put it in a recent groundbreaking article, increasingly at war with reality. In their article, Agency Finance in the Age of Executive Government, Michael Grieva and Krista Muth documented some, but only some, of the myriad deviations, the myriad ways in which the executive functions now as custodian of sorts of the federal government. In other words, executive functions of the federal government now are funded outside the traditional processes of congressional appropriations. Now, Grieva, there's been no, to my knowledge anyway, comprehensive survey of the changes, but they are there and they are massive. The Consumer Finance Protection Bureau, set up by the Dodd-Frank Act, passed in 2010, is perhaps the most high profile. The CFPB is funded through the earnings of the Federal Reserve. As I say, that's the highest profile and best known current example, but there are numerous others. Turning to state and local government finance, we see an ocean of money, a river of money maybe is a better metaphor, flowing from civil asset forfeitures and other of these policing for profit initiatives. We also see this, of course, on the federal level, but I put special emphasis on state and local government getting money from civil asset forfeiture and other policing for profit initiatives, because I think that those governments are more dependent on this money. And in conversations with many state and government officials over the years, many express misgivings, even real horror, real regret about a lot of what's going on in this area, but then say, but it's so hard to imagine how we will possibly do without this money. The most famous, or maybe I should say infamous, precedent, Supreme Court precedent on this score is the Bennis v. Michigan case, which arose out of a confiscation of an ownership, part ownership of a car Tina Bennis owned with her husband. And the car was confiscated after her husband used the car to solicit prostitutes, and confiscated as a public nuisance. So this was in effect justified, this taking of property was justified as a public nuisance abatement. We have, picking up on what some of Professor Nolette was saying, we've had civil asset forfeiture throughout the history of the United States, no question about that. That's the fact that it is a long-standing and well-established practice is one thing that makes the constitutional issues surrounding civil asset forfeiture so difficult. But the magnitude of the forfeitures and the effect and their effects on people are far greater than they have been, I would say, throughout our history. We also see a lot of fines that are disproportionate, or so I would argue, to any of the social harm that has been caused by the behavior that gives rise to the fines. Now, these developments, this taking of this confiscation of property, this imposition of significant fines and so on, are understandably very unpopular across the political spectrum. And so we are seeing significant movement in terms of reforms. A number of legislatures, state legislatures, of course, have already passed reforms. Some are considering reforms. And of course, there is the possibility of there being found, the civil asset forfeiture being found to be, or at least in some of its incarnations, being found to be unconstitutional. The Supreme Court, or at least some justices of the Supreme Court, seem to be receptive, perhaps, to the right case, in the right circumstances, might be willing to consider tweaking or even overhauling the existing constitutional doctrine. Now, this, of course, puts a lot of pressure on state and local governments. The financial pressure is there. The financial pressure is real. As I mentioned earlier, a lot of state and local government officials would like to draw back from some of these policing for profit schemes, but it is hard because the money is so great. And when we look at other revenue sources, other potential additional revenue sources, we see the pressure is as great or even greater. Raise taxes, well, that's tough, particularly given the economic carnage that has resulted from COVID-19 and government responses to COVID-19. We also, of course, look at the federal government, and there's also the issue of the SALT deduction, and so forth. Particularly in higher tax states, a lot of people are hurting as the result of the tax reform in 2017. That might be undone, of course, but we don't know. But in any event, raising taxes is difficult. Get more money from the federal government. State and local governments already get a lot of money from the federal government, as you know. Can they get more? Certainly the federal government has been able to distribute an awful lot of money to state and local governments in the last year and a half, but where are the limitations? The federal debt has climbed enormously. We're able so far to do this, but we don't know when or if we will ever see any difficulty for the United States to go into the world capital markets, as it's been able to do, or create money, if you want to look at it from that perspective. At some point, if the federal government begins to run into difficulty, state and local governments may be under even greater pressure. So that, of course, brings us to more novel liability theories. These are very, very, very attractive, I think, to be able to perhaps be serious sources of money. The tobacco settlement, of course, has continued to be an extraordinary cash cow, and it would only be normal for state and local governments to be thinking very hard about additional streams of revenue. There are, of course, things that make this more difficult. You are all familiar with the municipal cost recovery rule, which the Supreme Court case I just quoted from is sometimes listed or named as the origin or at least a very important cornerstone of this. The idea is that going outside that standard process of public finance is somehow illegitimate or somehow wrong. Nevertheless, we are seeing a lot of deviations from that standard process. These deviations, again, not new, but they have become greater. Exactly how strong is this municipal cost recovery rule? We certainly saw it in Illinois. The Illinois Supreme Court articulated a pretty strong version of it back in 2004 in a case involving a public nuisance case involving guns. But I would argue that it certainly is not a showstopper. All right, so what does this all mean going forward? I have no simple takeaway. I am certainly not here to say we have a standard process for funding government, for collecting funds and then dispersing them. We shouldn't deviate from that standard process. First, the standard process has not ever been the whole story, as Professor Nolette just discussed. And second, I certainly do not see the political will for returning to anything like the standard process. But I would like to close with three things, or three sets of questions that I think are particularly deserving of our attention. The first is public accountability and transparency issues. These are real and these are urgent. Yes, the public does demand action, understandably so, particularly for things that appear to be posing clear and present dangers to their health, to their lives, and to their livelihoods. However, these processes that we have been discussing that are outside the normal, well-understood processes, they are very opaque, or often quite opaque. It's very difficult to know if the electorate is being responded to or whether there is some kind of opportunity that is something other than public service being seized by some kind of government official. This is not to say that there are not many public-spirited, public-minded, public servant people involved in a lot of these novel liability efforts, but it is to say that it creates opportunities not only to serve the public, but also for what one might call looting. When we think about our constitutional system, one of the reasons that it has so many multiple veto points is to prevent opportunistic redistribution, is also to rein in oligarchy. Now, this has been no easy thing. As Professor Nolette was just saying, big business can result in concentrated corporate power. It is difficult to combat concentrated corporate power without the government being active in some way. And if you tie the government's ability to innovate, then concentrated corporate power may well go unanswered. These are important issues. They have been with us since the founding of this nation, and they continue to be difficult. I would, however, take public accountability and transparency very, very seriously as we act as citizens and as many of you act as public servants. Second point is about incidents. One of the toughest things, one of the things that makes transparency so hard in this area is that it is so challenging to figure out who is winning and who is losing, who is paying and who is receiving money. In a lot of the debates that we've been having about the various proposals that Congress is considering, there's been a lot, you've heard a lot about tax incidents, even some about spending incidents. We have well-developed, not satisfactory, but well-developed literatures on tax incidents. If we raise the corporate tax, on whom does that fall? Capital, labor, et cetera? We can make some good educated guesses. The same with a lot of government spending, just flat out government spending. We don't have as good answers, I think, as we would like, but we can make some good educated guesses about who will ultimately benefit from government spending. In this area of novel liability theories, there's not much of an incidence literature. And so going forward, I think, if we're going to go down this path, then I think it makes sense to look for and advocate for more sophisticated research, more sophisticated attention being paid to incidents. Finally, the constitutional issues. We could hold a whole other symposium on the constitutional issues that are arising as the result of these novel liability theories. First and foremost, I would put takings issues. I put takings issues first and foremost because takings, of course, can result in the normal remedy is to payment of damages. And so anything that could result in takings liability will have an immediate and negative impact can have an immediate and negative impact on a government treasury. So anyone acting on behalf of a government, I think, has to be particularly attuned to takings issues. But there are also due process issues. Due process issues, of course, loom large in civil asset forfeiture, including the civil asset forfeitures that are resulting from abatements of public nuisances and so forth. I expect tomorrow, with discussions of climate change, we will at least bump up against the issues of the Dormant Commerce Clause. After all, one of the things that our Constitution, the United States Constitution, was designed to do was to ensure national markets and so forth. There are a lot of ways in which some of what is potentially going on with climate change could have could raise significant Dormant Commerce Clause issues. There are also, of course, separation of powers questions, and these, I wish to stress, come up, as do most of these constitutional issues, in fact, not the Dormant Commerce Clause, but most of the constitutional issues come up at the federal and the state level. So I'll just close with one more point, which I think is an absolutely essential one. We're in a time of great interest, and I think this is a terrific development, great interest in state constitutional issues. Judge Jeffrey Sutton's books have gotten an enormous amount of publicity, some good sales and so forth. There are a number of other scholars working actively in this area. State constitutions are easier to change and in some ways more malleable, more dynamic, for good and for bad, than the federal Constitution. So I would expect there to be a lot of action, a lot of constitutional action, not only on the federal level, but also on the state level. All right, I've talked, I think, for long enough, so I will now turn it over to Professor Fitzpatrick.
Thank you, and welcome all of you to Nashville, Tennessee. The question that I'd like to raise today is, are these suits that the government entities are bringing, are they really necessary in light of the possibility of private enforcement of the law? Or to put it the way that Justice McKenna put it, would the public interest be better served if the government got out of the way and let the private bar do its job in many of these areas? Now, sometimes when these government entities are suing, they're suing to remedy harms to themselves. and this was true in the tobacco litigation to some extent. It's true in the opioid litigation to some extent. And if the government is suing to remedy its own harm, then private enforcement is a much harder alternative to think about. Sometimes government entities hire private lawyers to litigate these cases for them. We're going to have a panel later today all about that. Sometimes, like the federal government does, you can rely on a qui tam type statute to empower private lawyers to sue to remedy government's injuries. But I want to put those cases to the side where the government is seeking to remedy its own harms. And I want to focus on another category of cases that are increasingly common. And this is where governments, most particularly attorney generals, are suing to collect damages on behalf of injuries to their citizens. Not to the state government, but to the citizens of the people in the state. Again, like I said, these lawsuits are increasingly common. They're especially popular in the antitrust area, but it's also something that we see done in the consumer protection area. One of these cases went up to the U.S. Supreme Court recently. It was a case brought by the Attorney General of Mississippi. It was Hood v. AU Optronics. And the question in that case was whether when the Attorney General sues, does it count as a mass action under the Class Action Fairness Act, and therefore can it be removed to federal court, or does it stay in state court? But these cases are becoming increasingly common. Most of the time, they're authorized by statute. Many states have statutes that let the Attorney General sue when there are injuries to the citizens, say, under the consumer protection laws. There's also authorization via federal statute. The antitrust laws at the federal level also authorize attorney generals to sue to remedy antitrust violations and injuries to the citizens of their states. Some of these suits, however, are not brought pursuant to statutory authorization, but based on common law standing theories, parens patriae. The U.S. Supreme Court allows state attorney generals to sue for injuries to their citizens when those injuries are prevalent enough in the state. It's called a quasi-sovereign interest that states are allowed to pursue on behalf of their citizens. The object in this category of lawsuits that I'm focused on is to get money. The state wants to get money, and the state doesn't want to keep the money for itself. They ask for restitution for the injuries done to their citizens. They ask for disgorgement of profits from the companies that are sued, and they don't want to keep the money themselves. So it's a little bit different from the scenario that Professor Mahoney was describing. They either want to distribute the money to the citizens, but that can be really hard, as class action lawyers know, to find all the people that are owed the money. So more commonly, they give the money to charity. What is called cypre in the class action space is also used in these attorney general lawsuits on behalf of the injuries to the citizens of their states. So these lawsuits that attorney generals have been bringing, they could have been brought, and they sometimes are attempted to be brought by the private bar. And so my question is, do we need the attorney generals to do this when we have the private bar? And Professor Nolette said, some of these private class action lawsuits, you might look at them as redundant given the government's action. I would frame the question the other way. Is the public lawsuit redundant given the private action? And sometimes there's no redundancy at all because the public action actually displaces the private action. There's not a lot of law out there on the res judicata effects of a public action and whether that will give a peace to a corporate defendant and therefore prohibit a private class action lawsuit for the same injuries. There's not a lot of law out there on that question, but the majority view that is out there on the question is that yes, when an attorney general sues under one of these statutory authorizations or under the parens patriae power, it prohibits another lawsuit by private class action lawyers for the same sets of injuries. So when the government gets involved, it can actually crowd out private enforcement of the law. Some courts have also held under Rule 23, which is our class action rule of civil procedure, one of the elements in order to certify class action is you have to show that the class action is a superior method of adjudication compared to the alternatives. Some courts say, well, given that the Attorney General is suing, the class action is not a superior method of adjudication, and I'm not going to certify a private class action for this cause of action. And so these are two ways in which the government getting involved crowds out private enforcement of the law. And when the government gets involved, there's no requirement that all of those procedural protections that we put into the class action Rule 23 apply to the government. So if you seek money damages under Rule 23, you have to give notice to all the class members and give them an opportunity to opt out. None of those restrictions apply when the Attorney General sues on behalf of the citizens of the state for antitrust violations or consumer protection violations. And there's a wonderful article, it's not in our materials for today, but a wonderful article in the Harvard Law Review by a Duke professor named Margaret Lemos. It came out in 2014, and it's called When Aggregate Litigation Goes Public. And she describes many of the issues that arise when attorney generals sue and potentially crowd out class actions or do not offer the same protections to the citizens of the state that would be given to those same citizens if they were members of a class action. But I don't want to restate what Professor Lemos said in that article. I want to raise this slightly different question with you today. And that is, would we be better off just letting the private bar do their work and getting the government out of the way? Why do we need the government to try to collect damages for the citizens when we have all these private class action lawyers willing to do that work for us? And in my view, the public interest is better served by the class action lawyers than by the attorney generals. I'm sorry to my attorney general friends who are in the audience today, but I think the class action lawyers usually do a better job than even our attorney generals do. And I made this case in a book that I published a couple years ago called The Conservative Case for Class Actions. And many of the reasons I prefer the private bar to government suing on behalf of its citizens instead are unabashedly ideological reasons. You know, the book is called The Conservative Case for Class Actions, and many of the reasons in there are unabashedly ideological reasons I prefer private lawyers over government lawyers. But most of the reasons in the book are in fact neutral, utilitarian type reasons why I think the private bar usually does a better job than the government. And I want to go through a few of those reasons with you today to try to make the case that the government should stand out of the way and let the private bar do its job. Number one, incentives. How do the private bar's incentives compare to the government's incentives? The private bar is profit motivated. Private class action lawyers only get paid on contingency. That means they don't get anything unless they produce some results, and then they get a fraction of those results as their pay. Government lawyers are on salary. They don't have the same incentives to pursue wrongdoing that profit-motivated actors do. In addition, as Professor Nolette described at length, government actors have other motivations entirely, and that can be the political motivations. Now, at their best, political motivations are, I really want to help the community. At its worst, the political motivations are, I really want to punish a company that contributed to my opponent. I really want to reward constituencies that supported my election. And I think when you compare these two worlds of incentives, I prefer the profit-motivated private actor to a potentially politically compromised government actor or a government actor that doesn't have the same fire in the belly because they are paid a salary no matter whether they file a lawsuit or not, no matter whether they collect a lot of money or not. I prefer the profit motive. Now, can the profit motive go too far? Yes, of course it can. But I think we can control a profit motive much better than we can a non-economic motive like a politically motivated government enforcer has. We control the profit motive by tying the profits to the results. It's a little bit harder to control a political motivation because the Attorney General may not even need to win the suit to get whatever benefit politically that the Attorney General wants to get from filing that lawsuit. And so I think it's much harder to control those incentives. And so I prefer the profit motive because I think it produces better results because we can tie the profits to the results in a way we just can't do that with political actors. Number two, resources. There's a lot of concern in Professor Limos's article that when the Attorney Generals pursue wrongdoing, they don't have the resources that the private bar has. And I tend to think she's probably right about that. You know, private lawyers, because there's profit to be made, they can get financing for their ventures. The Attorney General's office, they're leanly staffed, and according to Professor Lemos, and I think she's probably right, they don't have access to the same resources to pursue wrongdoing, and therefore she worries they don't get the same kind of results that the private bar does. The third reason I think the private bar is superior is bias. This goes back to the politics that we talked about before. We have a fancy word for it in law school. We call it agency capture. There are more colloquial words used for it out there in society, like crony capitalism. But the government has a lot of different influences on it, some of them good and some of them bad. And I would rather have an enforcer like the private bar that is single-mindedly focused on profits than a government enforcer that is subject to capture by the industries that they seek to pursue, or they could go after one company and not another because of some relationship with the executives of that company or what have you. And again, I think this is an inferior way to enforce the law than to have a single-mindedly focused profit enforcer, which we can control very well with economic incentives. And the last reason why I think private enforcement is generally better is private enforcement is more decentralized than government enforcement. When we ask the government to do things, to a certain extent, we put all of our eggs in one basket. If the government does a good job, great. If it does a bad job, not so great. With private enforcers, there's more diversity of enforcement. There's different lawyers at different times in different places trying different things. And we get more experimentation, innovation, and we get more security than having all of our eggs in one basket. And so for these reasons, I tend to favor the private solution rather than to ask the government to pursue these wrongdoers and try to distribute the damages to the citizens. And so my recommendation would be, whenever possible, for the government to get out of the way and let the private bar do its job. Thank you very much.
Thank you for those wonderfully, just really illuminating presentations. Thank you. You've made me, and I'm sure many members of the audience, think about things that in a different way, ways that we hadn't considered these issues. So let me first start by asking if any of you would like to comment on any of each other's presentations. Please, go ahead.
I did have one question on, so Professor Fitzpatrick, I mean, so I think, you know, I even describe these kind of class actions and some of the AG suits, public entity suits, as potentially redundant. And I think that there is a certain redundancy there when you're focused on the money aspect, at least. But I wonder, you know, to some degree, what the class action suits and what the AG suits are trying to do is in many ways different. I mean, the class action lawyers are focused mostly on the money, compensation, whereas AGs, even sometimes the dominant reason for these, certainly like multi-state suits, the bigger ones, is not even so much about compensation, but more about like preventing harm from the future and thinking about ways, really in kind of a regulatory sense, how do we address things like data breaches so they don't happen again? And so I wondered to what extent, you know, things might be lost if we didn't have AGs enforcing this in ways where they can specify in settlements, you know, what the corporate responsibilities moving forward will be, put into place compliance monitoring, whether it's independent monitoring or however that's structured, in a way that cuts down on future problems. Because so in some ways, the AG view of this might be more forward-looking as opposed to just being reactive and saying there was a violation, let's go after it. Instead, it's more like, how do we prevent violations in the future?
I think it's a great point. Of course, it's possible for the private bar to also seek injunctive relief in addition to damages. However, I think you're right that because it's harder to tie the profit motive to the value of an injunction, the private bar doesn't have the same incentive to pursue injunctive relief that it does damages. And I do think this is an area where the attorney generals can add value. I think that injunctive relief is a place where the attorney generals can do something. They may have a comparative advantage over the private bar there. And that's why I tried to focus my presentation on this category of lawsuits where the attorney general is seeking damages. There, I think the comparative advantage of the private bar. But I think you're absolutely right, Professor Nolette. On the injunctive relief, the comparative advantage may be with the attorney generals.
Anybody else wish to comment?
I just have a quick question for Professor Fitzpatrick. Can you say more about these money going to charity?
Yes.
Because to many, charity, quote unquote, can be one person's charity is another person's slush fund.
It's another corrupting opportunity.
Particularly where 501c3 status, 501c4 status, this can get very gray. So
it can be another corrupting opportunity.
Exactly.
And, you know, I'm most familiar with the Cypre controversies involving class action lawsuits. I have to admit that I am not as well educated on where the attorney generals are sending their Cypre money. Maybe some of our attorney generals, if they've participated in those kind of distributions, can illuminate us on that. But there have been a lot of controversies even on the private side with Cypre because some of the charities that are selected are related to the lawyers or the judges. So this has caused a lot of bad publicity in some class action cases. Now, I don't know, again, if the attorney generals have run into the same problems, if they are picking charities that might advance their political goals rather than something that's going to serve the interests of the citizens. You know, the theory behind Cypre is if you can't distribute the money to the people who are harmed, do the second best thing, the next best thing. And so typically, you know, ideally, we try to find some charity that benefits the people who were harmed, often in some way connected to the way they were harmed. So in some of these situations where there's been consumer fraud, a popular charity that is picked in class action lawsuits is financial literacy organizations to help people make better choices about the products that they purchase, the fine print that they encounter, et cetera, et cetera, et cetera. But, you know, again, these things can deviate very quickly into the alma maters of the lawyers, the alma maters of the judges. We had a case here in Tennessee not too long ago. I think it was a healthcare fraud case, maybe a securities fraud case with a healthcare company, I can't remember. And the judge, it was a state judge, decided that he wanted a portion of the settlement to go to buy hockey tickets for poor kids. Now, that's a wonderful cause, but it had nothing to do with the healthcare fraud in the lawsuit. And so you definitely have opportunities for questionable decisions when you have a big pot of money that you get to throw around with not very much oversight.
All right, I think there's a lot of great audience questions, so I'm going to direct some of the audience questions now. and I'm going to combine some of them. In terms of separation of powers, Professor Mahoney, I think there's the issue of vertical separation of powers between the state government and the local governments. And are you seeing issues arising out of that in terms of incentives or difficulty in settling cases, or are there any special issues that arise out of, like, some of these cases? The state attorney general could bring them, but now we have localities, local governments bringing these cases.
Yes, great question. We've seen a lot of course, tension between state governments and local governments. Some state governments may look at recent activity by local governments as in a way horning in on what had been traditionally the province of the state governments. It's always been difficult to figure out exactly where those realms of responsibility are. And of course, states have different attitudes, different approaches to the powers of local governments. So I think that we definitely see an enormous amount of activity on this front. And
I'm just really curious, are you aware of it, whether there's any cases in which, you know, the state government has sought to intervene or say, hey, the state is an indispensable party to this. These are our claims, not the local government claims.
I can't think of anything offhand, but there may well be. Have you?
Opioids, for sure.
Oh, right, the opioids,
because,
right.
I mean, you have a number of the state AGs coming in, and you know, there were a number, I think, you know, Ohio was involved there, Arkansas, and a number of AGs filing amicus briefs supporting the idea that, you know, the state should be controlling this litigation.
And in the tobacco settlement, it was only the states, is that right? And the local governments weren't involved.
And that's a big reason why many of the local governments said, we don't want that happening again, because look at all this tobacco money didn't even go to, you know, tobacco-related programs, it went to other things.
Yes, another thing that I think bears emphasis is how the tobacco settlement, which was billed as going to go to public health and tobacco cessation programs and so forth, it's turned into a kind of general.
That kind of supports your theory that this is a method of public financing. It's really going into the general fund.
Absolutely. When I watched the tobacco settlement with great interest. And besides opioids, where else have we seen? We're seeing tension there now as the settlement talks continue.
Yeah, and I mean, really, since the wake of the tobacco settlement, that's where I always kind of look at a lot of the public entity litigation coming in a couple waves. One, in the wake of the 1960s, 1970s, like all that consumer protection, antitrust legislation that empowered public entities to bring lawsuits. But then, especially once many of the public entities figured out their power here to really restructure an entire nationwide industry with the tobacco litigation. Since that time, in the last 20 years or so, you've seen a number of other industries, certainly pharmaceuticals, but others more controversially, perhaps like guns and things like that, where you have even some local governments bringing lawsuits and causing a number of both political and legal tensions with the states.
Like the city of Chicago spearheading the gun suits, yes.
Professor Fitzpatrick, you've talked about how you believe it should be the private bar, but one of the questions is, isn't it true that many attorney generals are actually hiring private attorneys to prosecute claims on behalf of the state?
Yes, and I believe that's our next panel, is going to talk about when the public entities hire private lawyers to do the pursuing. And you know, I think that has a lot of minuses and a lot of pluses, and I think it probably introduces more problems than it solves, because you know, there can be very cozy relationships between the Attorney General and the law firm that the Attorney General hires to pursue the case. And so I think it comes with a lot of baggage. And I looked at it and I thought about it some for my book, whether this would be maybe the best of both worlds. You have the less profit-oriented public involved with the profit-motivated private. Could this be the best of both worlds? And kind of when I went through the pluses and the minuses, I ended up concluding it was the worst of both worlds. But I won't preempt our next panel by going too much further into that.
Let's see. Sorry.
Can I ask a question of Professor Mahoney while we have a moment?
Yes, please.
Justice,
please.
And that is, You know, so I am very high on the profit motive of the private bar, and I don't think, you know, the public entities are profit motivated in the same way. But then when I hear you speak about how these public entities need this money because they don't want to raise taxes, it makes me question whether I'm right about that. Do you think these public entities have a profit motive that is akin to the one that a private lawyer would have?
Up to a point, yes, but I think that they're very different, as you've been pointing out, the motivations. I'd put it this way. It is not accurate to say that the governments are inattentive to the staggering revenue possibilities here. The tobacco settlement, certainly, for anyone who hadn't figured this out already, this would have made that very clear. But you're right. When you think about the fact that it's not the government acting as a monolithic entity with the government's interests, it's individuals working in the government, each of whom has their own complex set of interests, career, public service, et cetera, bureaucratic. It does get complicated.
There's a related question, and that is how much of the incentive to bring these lawsuits is driven by the way AG offices are funded, including when they must find their own budgetary funds. Are there some AG's offices that they have to fund themselves, find funds for themselves?
There's certainly, there's certainly financial pressures on many decision makers, no question about it.
I see.
So does the AG's office get to keep any of the money that they collect, I wonder?
I don't know. It looks like some people, yeah.
In some cases, yes. Think about it, years in which the legislature threatened to zero out the AG's funding last day, which I will not mention. It turned out at the same time we were collecting a fairly large settlement from some public investigation that resolution. But we will bill for time spent on litigation. The agency will bill for its attorney's time.
And this is from Alabama, by the way, is that right? Okay. Very
So you basically collect
very
a fee
interesting.
from the settlement. You collect a fee from the settlement.
How about a
Gotcha.
success fee?
Wow.
No success fee?
I don't know about. I know that our office tracked and recovered as part of specifically the Exxon Valdez, not Exxon Valdez, I'm sorry, but the Gulf spill.
Right.
But yeah,
Right.
which was a massive undertaking for our office and a lot of attorney time spent on it.
Okay, great. I'm a little concerned that everyone might not have been able to hear, but apparently in Alabama there are incentives for attorneys general's offices to collect some fees from these settlements and litigation. So that's very interesting. I think different states probably have different systems. But that's also true, I understand, of some courts too, right? I mean, some courts have to have, some state courts or municipal courts have to seek some of their own funds also. So,
And I think, you know, that is one thing that definitely stands out when you're looking at all the different AG offices, is that there's a lot of variation there, just in terms of where the money goes. And in fact, sort of a question for Professor Mahoney, but also kind of a general one to you as well. AG staff is kind of thinking about, like, are there sort of best practices, or are there, you know, laws that states should pass that get to the accountability and transparency arguments, while also realizing that the AGs are putting a lot of staff hours and time and decision making into this. Like, what's the best balance between having some of that money, for instance, fund future consumer protection efforts versus just going into the general fund or being dictated by, the legislative branch as opposed to the AG office?
Well, excellent questions. I mean, if you have it all going to the general fund, then you have money appropriated in a way that is transparent and is quite well established and is quite well understood. So from that perspective, what's happened to the tobacco settlement money, maybe that was a good thing. On the other hand, there's a certain sense of bait and switch that many were expecting one thing and then got something else. So that's given the tobacco litigation, I think. I wouldn't say that it has brought it into disrepute. That would be overstating things. But but the events of the tobacco settlement, I think, made a lot of people go, we were told that this money was going to go for particular purposes, specified purposes, purposes to in effect fix harms or to things that are connected, where there's an essential nexus between the behavior of the tobacco companies and the social harm we see going forward. And instead it ends up in the general fund. And I don't know the answer to that question. Is that a problem?
Can I ask you a question about that, Professor Mahoney? If the legislature approves the lawsuit and the governor signs on to the legislature's approval of the lawsuit, does that mitigate some of these transparency concerns that you're raising?
I think it mitigates it a little bit, but this is great because it reminds me that the non-delegation doctrine is more robust at the state level than at the federal level. Not that it's not existent on the federal level, but a lot of under a lot of state constitutions, the non-delegation doctrine is taken quite seriously, exactly for reasons for some of the concerns that you're
And Professor,
referring
could you briefly explain the non-delegation doctrine?
The idea that legislatures cannot simply, in effect, vest their power into other branches. It's one of the hottest issues in debate, constitutional debates over the so-called administrative state. To what extent can Congress pass laws that say, okay, everyone, all you agencies, you fill this in? That's been one of the ways that Congress has been acting in the last decade in particular. It's now, some might even say that it is standard operating procedure to have very, very broad statutes that don't look like the statutes of a few decades ago, but instead look like almost concepts or general directives to agencies to make rules, send your colleague letters, and so on, and in effect fill in the gaps. Is there a point at which the Constitution says no? There's a the non-delegation doctrine at the federal level has been, I would say, moribund, although there have certainly been some signs of life in the last few years. The non-delegation doctrine exists and is more robust in many states. So that's another thing to bear in mind when thinking through all the issues that arise out of these so-called novel liability theories.
Go ahead.
And it is pretty rare, I think, across the country for governors or the state legislature to have to sign off on these AG lawsuits. And I mean, it has come up more recently. I mean, in my home state of Wisconsin, there was a new policy where a state committee had to sign off on settlements that the Wisconsin AG was involved in, and the AG has responded saying, this is a violation of separation of powers. You're getting involved in my authority in a way that's inappropriate for the legislature to do. So those battles might be actually picking up, especially, and there's a lot of kind of partisan aspects to that as well, but that might become more common, but traditionally, I mean, that hasn't really been, the AGs have a lot of independent authority.
Yes, but my impression is that these battles are picking up.
Mm-hmm. Yes.
There's a couple questions relating to the transparency issue, and one is transparency really an issue because of this is happening so much, the increased use of these lawsuits and the publicity behind these lawsuits? And the other transparency issue is, is transparency better served by having robust civil fines by localities rather than asset seizure and or disgorgement of profits?
Any thoughts?
I mean, I think just generally on the transparency thing, and I'll just say from my perspective, because I've kind of looked into this, one of the things that I'm interested in is like, okay, there's this big settlement announced, and all the press releases go out and they talk about the money, millions of dollars, and it's like, where's the money go? Like where does it actually end up? Even if it goes to the general fund, where does that money go? And it's like impossible to find most of this. I mean, obviously states differ on this in terms of the transparency, but it's really, really difficult to know where the money goes and how it's being used. And I do think that is a concern.
So unfortunately, we've run out of time. I've been told we need to end at the designated time. So if anyone has additional questions, please feel free to come up and ask the panelists. But this has been a wonderful presentation by all three panelists. Thank you so much.